Hi Miss, my name is Pratibha Nandini Sivaraja, student ID DM05283. Today I'd like to present about introduction of player bargaining. Player bargaining is an informal process that operates largely outside the formal legal system Alcon 2015 before it has been codified in leisure in year of 2010. During the post-World War II, the player bargaining often has been said construct of the court where it rewards those who appear guilty rather than who claim innocence. Volger 2012. It has been said in plea bargaining, offender agrees to waive their legal rights to a trial for only for prosecutors or the court. Lipke 2013. The institutional perspective says that different courts that have different norms about the outcome at trial will also have different outcome for players. Bushway and Redlich 2012. In another country such as the United States, their bargaining process is unrestrained because the prosecutions and to certain extent judges have wide discretionary powers to offer reduced punishment to individual who has formally accused of crime. Lipke 2012. Plea bargaining refers to a person charged with a criminal offences negotiating with prosecution for a lesser punishment than what is provided in law by pleading guilty to a less serious offence. It is common in the United States and has been a successful method of avoiding protracted and complicated trials. As a result, conviction rates are significantly high there. It primarily involves pre-trial negotiation between the accused and the prosecutor. It may involve bargaining on the charge or the quantum of sentence. Upon successful plea bargaining between prosecutor and accused, the resultant is the plea agreement. The term plea agreement has been defined as an agreement entered into between the prosecution and the accused in the criminal trial in accordance with the section 194A, 194B, and 194C of the Criminal Prosecution Act, Cap 20.
A very good morning, Miss. My name is Kishana. I am from DEM 062002. Today I am going to present about types of plea bargaining. There are three types of plea bargaining which are parties with normally negotiative, namely charge bargaining, count bargaining, and sentence bargaining. Charge bargaining occurs when the accused and the public prosecutor enter into an agreement to plead guilty to a lesser offense than the original offense he was charged with. For instance, the accused was charged with an offense for causing grievous hurt under Section 325 of the Penal Code, but he agreed to plead guilty to a lesser offense on causing hurt under Section 323 of the same code, which carries a lighter sentence as compared to the previous section. The type of plea bargain available to a defendant is usually determined by the defendant's criminal history and the severity of the current charges. Regardless of the type of agreement used, a judge will have to approve the agreement before it takes legal effect. A judge can refuse to honor the terms of an agreement if it seems to look too lenient or too harsh. The second type of plea bargaining is the count bargaining. This type of plea bargaining can be seen in a situation when the accused was charged with more than one offense. For instance, the accused had committed 3 offenses, which are robbery, grievous hurt, and rape. The open agreement between the parties, the accused will plead guilty only to a single offense, usually that of a lesser degree, in exchange of the other 2 offenses being discharged. On the other hand, sentence bargaining is when the accused agreed to plead guilty on the offense that he was charged for his reduced sentences which had been agreed by both parties, namely the prosecution and the accused. Despite the three types of plea bargaining mentioned, it has been agreed by some authors that the common types of plea bargaining are charge bargaining and sentence bargaining. Charge bargaining is an agreement where the defendant pleads guilty in return for a lesser charge. This often takes the form of reducing a felony of a misdemeanor. For example, reduce a drug taking charge to a drug possession charge. By reducing the charge in plea negotiation, the accused may avoid mandatory minimum sentences for certain types of convictions. It may also allow the defense to preserve certain civil rights for their claim, like the ability to process a firearm. Usually, the agreement will include specific sentences called bargaining or plain and bar. Involves negotiating how many charges the accused person will face. While they might have committed several crimes at the same time, a plea deal could reduce the number of charges bargaining and can result in a lighter sentence if the prosecutor agrees to a particular set of facts about the crime. Sentences bargaining is when the defendant agrees to plead guilty in return for a lighter sentence. Some judges have a wide range of possible penalties for low-level cases, and sentences bargaining could guarantee that punishment is a fine with no jail time. For more serious cases, the sentences bargaining might take years of prison sentences or convert prison time into probation. Incomplete plea bargains can also exist when the two sides are also to an agreement but can quite pin down the exact terms. When this happens, the two sides present their incomplete agreement to their judge, who then hears from both sides about the remaining details. This is sometimes called a sentencing cap. For example, a defendant charged with a robbery that crimes a maximum sentence of 10 years in prison. During the plea bargaining process, the two sides might agree that the defendant will spend at least 1 year in prison, but cap the maximum sentence of 5 years. Each side will then argue before the judge for the sentences they think is appropriate based on the defendant's criminal history and the facts of the crime. The judge will then order a sentence between 1 and 5 years. Thank you.
Hello, my lovely lecturer and my friends. So my name is Kirubagaran Bhaskaran. My ID number is DEM 05200004. So I will talk about the advantages of plea bargaining. So the first one is it's remove uncertainty from the legal process. Its main defenses would take a plea bargain, eliminate the uncertainty that a trial may bring. It is also a way to take away the maximum sentence that could be imposed if they were found by a judge or a jury. In the United States, nearly 500,000 people are held in prison with charges but are awaiting trial, which means they do not have a conviction. Plea bargaining speeds up this process. Okay, the second one is it creates currency for a conviction. It means prosecutors are also grabbing when they take a defendant to trial. This is also a chance that the juries will find the defendants not guilty by agreeing to a plea bargain. Okay, the third one is it can be effective negotiating tools. It means one way to secure witness for a large case is to offer a plea bargain that includes testifying against other person. Okay, the fourth one is it provides more resources for the community. It means if a case is taken to trial, every police officer involved in the investigation that lead to charges may be asked to testify during the proceeding. Okay, the last one is it's reduced population level in local jails. Many who are awaiting trial are kept in jail at the local level. So those jails are usually run by city or country official and provide little in the way of rehabilitation education. Okay, so that's all from me. Thank you so much.
Hi Miss, my name is Pravina Sri and my ID is DEM05200071. Today I am going to talk about disadvantages of plea bargaining. Firstly, it removes the right to have a trial by jury. In the United States, every person has a constitutional right to have a trial by jury. Offering a plea bargain to avoid this trial may seem like a conceived attempt to waive those rights. Pressuring a defendant into accepting a plea deal could be deemed illegal. A defendant must always have the right to take their case to trial for a plea bargain to be an effective tool. Secondly, it may lead to poor investigatory procedures since 90% of cases in many jurisdictions go to a plea bargain instead of a trial. There is an argument made that this concept leads to lackluster investigation practices. Instead of trying to secure justice, the goal is to make a deal. It could be argued that expecting a deal really is not justice. Thirdly, it still creates a criminal record for the innocent. An innocent person may agree to be a plea bargain to cut their losses. That agreement means they will have a criminal record. Even if a plea bargain is not accepted, there may be legal expenses to pay that may be greater than the cost of what a bargain offers, which leads to an acceptance of a deal. Fourthly, judges are not required to follow a pre-bargain agreement. The prosecutor and defendant may agree to be a plea bargain, but the judge can avoid that agreement. A judge is not usually required to follow a plea bargain. A judge can also require a case to go to trial if they feel like a plea bargain is being offered in bad faith. The last point, it provides soft justice for the guilty. In many circumstances, plea bargain provides a lighter sentence for someone, even if they may be guilty. It can be treated as an escape route for a prosecutor. Some may argue that a guilty plea and a guaranteed sentences is not the same as being found guilty in having accurate sentences imposed. Thank you.
Hi Miss, I'm Tisha Tirchelman from DM batch 21. My student ID is DEM05200048. Today I'm here to explain about findings of plea bargaining. The overwhelming majority, 90 to 95% of cases result in plea bargaining. Prosecutional discretion in plea bargaining is known to cause discrepancies in sentencing outcomes. Those who go to trial rather than accept a plea are more likely to receive harsher sentences. Legal variables, including the seriousness of the current offense and prior record, are important factor in determining whether a charge will be reduced by and by how much. The majority of research on this case and sentencing outcomes shows that blacks are less likely than whites to receive reduced pleas. As last, both legal and extra-legal characteristics are heavily influenced by prosecutorial discretion and by the region where the case is processed. That's all from me. Thank you.
My name is Ashmita Steven. My part in this plain bargaining is research questions. First question is, what are the guidance of the party plea bargaining procedure in deciding its terms? The answer is, in these facts there are no determining the terms in plea bargaining process and did not provide the guideline on how to determine the terms in itself. The paper aimed to see what are the standard guidelines applied. The second question is, is plain bargaining fair to the victim? Of course, my answer is yes. Plea bargaining allows victims to avoid testifying in court, which may be frequent or upsetting, especially for the victim of violence crime. Some victims also appreciate the certainty that provide the plea bargaining. Okay. What will happen if plea bargaining never found? If plea bargaining is never found, administration necessary without it, court will be flooded and justice process will get bogged down, and plea bargaining saves the prosecution and the court and defends the cause of the trials. What is plea bargaining in Malaysia? Plea bargaining will only be offered within 13 days after the person being charged, and the case will be go trial after 30 days if no agreement be gathered. The plea bargaining will be opinion in a case involving first time offender only. If you agree the plea bargaining is unfair, yes, because defense forgets some of their rights, including their rights to trial by jury. Okay, the last question is, do you think plea bargaining is ethical? Yeah, because enormous power of the prosecutor combined with the plot of plea bargaining creates an largest and ethical dimension of prosecution. Thank you.
Miss, I am Kugubi, DM05298, and today I'd like to explain about the problem statement of plea bargaining in Malaysia. So I'd like to explain the two types of the problem, which is discretionary powers of public prosecutor and the guidelines in deciding its terms. So the firstly, when the accused agreed to plead guilty under plea bargaining, the case will be disposed without a trial, provided both parties should reach a mutual agreement on its term as discussed. In the case of public prosecutor, which is V. Azizul Aisha, it depends on the prosecution as to decide whether or not or to apply the plea bargain to each case, and the court only needs to ensure that he or she terms in plea bargaining were entered into the voluntary by the parties provided. Once the court has passed its sentence based on the plea bargaining terms, the parties cannot appeal the decision except on the technical ground. So this is the first part of the disciplinary powers of public prosecutor. And second, I'd like to explain about the guidelines in the deciding its terms. And firstly, the provisions regarding plea bargaining on the set of the procedures on how bargaining should be done, and but not guidelines for the parties in determining on its terms. Moreover, it will lead to, especially with there are similar facts in the case and different courts pass different sentences. So this is the second part of my point. So the third part will be explained by my friend. So thank you so much, Miss.
Hi everyone, so my part is inconsistencies in plea bargaining application. The inconsistencies in the plea bargaining applications can be seen in the several issues with minor facts, but with the different outcomes as the parties agreed on different themes. With such inconsistencies can be seen in the case involving the positions of drugs, namely public prosecutor, that's V. Manimaran Analaki Manikam, where the court refers to the case of Subramaniam Arumugam v. public prosecutors, which shares minor facts, but the court passed lesser sentence to be a behavior weight of drugs, as what has been agreed during the plea bargaining process. The situation may lead of unfairness towards the accused's person, as it somewhat to suggest that the theme and the play beginning sentence to be cornered and court of charge.